Chairman Nadler, who may be here, and to all the members of the House, 140 of them in total, that have joined this bill, 34 members of the United States Senate, my colleagues, and they are all with us in spirit for this historic announcement. There's a lot of use of the word rigged these days, as in rigged system. One of the systems that is truly rigged against consumers and workers and the American people is our current system of forced arbitration. Forced arbitration is unfair, unjust, un-American. Truly un-American, because one of the principles of our American democracy is everybody gets their day in court. Forced arbitration deprives people of that basic right to a day in court, in public, on the record, fairly before a neutral decision maker. Forced arbitration, frequently hidden in the tiny print of a contract, means very often the company chooses who the arbitrator is, the proceeding is in secret, and the outcome is likely to be unfair, and people are prevented from joining together in a common cause or class action. That is fundamentally unfair and un-American, and that's why we are introducing the Forced Arbitration Prevention Act. It is known officially as the FAIR Act. The FAIR Act would essentially prevent any forced arbitration as a result of an agreement pre-dispute. Employees or others would be able to resort to arbitration if they so choose after the dispute, if it's to their advantage, but not forced as a result of any agreement before the dispute. So this bill is basically about guaranteeing every individual their day in court, about affording them that opportunity to walk through a courthouse door and have a judge make a decision, a judge who is chosen not by the company, but by the people of this country. And no longer should people be forced to suffer in silence, to endure the unfairness of this kind of rigged system, stripped of their rights, and forced to go before a non-neutral arbiter. The scale of forced arbitration is absolutely astonishing. Tens of millions of Americans every year are compelled to go through this process. And Americans understand what's at stake. By majorities of 8-1, they tell us that they believe forced arbitration is unfair. And you're going to hear from one of the most distinguished pollsters in the United States about the results of that survey. You're also going to hear very graphically and dramatically from people who have been forced to suffer through this rigged system. Some of them have been here before. Kevin Zeiber, Akilah Edwards, Tia Holman, and Gretchen Carlson all were here last year. Now, you may ask, what's different this year? First of all, the House of Representatives will pass this measure. Second, as these stories will convince you, Americans are overwhelmingly aware now by very significant majorities about how forced arbitration is fundamentally unfair and un-American, and they're willing to stand up and speak out about it. Not only Democrats, but also Republicans. This cause is truly bipartisan. It should be supported by both sides of the aisle. I'm convinced that if my colleagues hear and heed the American people, we will pass this bill this year. And you will hear how consumers have been denied rights, employees have been treated unfairly, antitrust implications, as well as civil rights. This bill is truly a civil rights statute. It gives people that day in court that they need and deserve. And so I'm going to now turn over the podium to Tori Voigt, who will introduce some of the individuals who've been affected. But keep in mind that the Forced Arbitration Injustice Repeal, Forced Arbitration Injustice Repeal, the FAIR Act, is fundamentally about fairness. And these individuals have the courage and the strength to stand up and speak out and give face and voice to this cause, and I'm very much indebted to them. We may be joined by our House colleagues as we move along, and we'll interrupt to introduce them. Tori?
Thank you, Senator. I'm very honored to be here today to introduce a plethora of speakers from across the country who were brave enough to share their personal experiences with you all, starting with Tanuja Gupta from New York. I just wanted to leave a caveat. Please refrain from any questions or applause until everybody has had a turn to speak. Thank you so much in advance.
Thank you to Senator Blumenthal, Congressman Johnson, and Chairman Nadler, as well as the rest of members of Congress who are joining us today to announce these historic bill introductions. I stand before you today joined by workers from all backgrounds, as well as assault and harassment survivors, consumers who have had their money illegally stolen from them, families who can't get justice for a loved one in a nursing home, and a Navy reservist who was fired for taking time off to serve his country. What is the one thing they all have in common? Forced arbitration. These words, buried in the fine print of everything from employee handbooks to credit card agreements and nursing home forms, strip individuals of the power to seek justice and accountability when their rights have been violated. But the time has come to end forced arbitration. In the last 2 years, we have seen journalists and frontline engineers put tech companies in the spotlight, forcing changes around how we address discrimination and harassment in the workplace. We watched as some companies tried to create policies in a more surgical fashion, carving out only a narrow category of cases where justice might be received. But workers continued to beat the drum of intersectionality and highlight the root cause of all inequity, the structural imbalance of power. And slowly, some companies started to relent, rolling out blanket policies that eliminated forced arbitration. Now time is up for all corporations, all their subsidiaries, all their suppliers across all sectors. We come here today not as employees of the same company or as even colleagues in tech, but as 6 of the 60 million workers in America that are denied access to justice. We come with our own experience to know that no worker is safe until all workers are safe. No consumer is empowered until all consumers are empowered. We call on Congress to quickly pass the Forced Arbitration Injustice Repeal Act. We cannot have an honest conversation about labor rights or restoring consumer protections until we pull back the curtains of forced arbitration, which denies employees and consumers their ability to fully and publicly vindicate their rights. It's 2019, and time is up.
Thank you. Great.
Thank you so much. Next, I'd like to introduce Kelly Stein from Kentucky.
Good morning. My name's Kelly Stein. I'm from Louisville, Kentucky. And my mother, June Lee, was severely mistreated at a nursing home. There were severe lapses in care protocol that led to diminished physical and mental health. And when I tried to hold the nursing home accountable, I was forced into arbitration. My mother was a union leader, and she fought for teachers' rights and was an outspoken advocate. And she would have not wanted these rights to be taken away from her. Forced arbitration took away her rights and my family's rights. That's why I'm asking Congress to end forced arbitration and restore justice for me and for all Americans.
Thank you so much, Kelly. I'd like to introduce Richard Higgins from New York.
Thank you. I'm Richard from New York. I used to work at Chipotle. They made me agree to arbitrate any disputes before I could work. On closing shifts, Chipotle clocked us out automatically, made us keep working without pay. When I brought it to their attention and complained, I got fired. I tried to join the court case, but I was forced into arbitration. And it's also forcing thousands of others to be in that arbitration just to try to get our money back. Forced arbitration took away my rights. That's why I'm asking Congress to enforce arbitration and restore justice for me and all Americans. Thank you.
Thank you, Richard. I'm going to interrupt to introduce Representative David Cicilline from the great state of Rhode Island.
Good afternoon. I am delighted to be here, and I want to begin by thanking all of the workers and veterans and advocates who are here with us today. I would also like to thank Congressman Johnson, Senator Blumenthal, Chairman Nadler, Chairman Scott, and Chairman Takano for their incredible leadership on restoring Americans' legal rights by ending forced arbitration, and also like to thank Congressman Sanchez for being with us today as well. I'm incredibly proud to join Senator Blumenthal today as we announce the introduction of the Justice for Service Members Act, a bill that will safeguard the rights of service members, veterans, and their families. American service members, veterans, and their families have sacrificed enormously in service of our country. They fought to protect the fundamental idea that we're a nation of laws and institutions that guarantee the rights and prosperity of every American. We are a stronger nation because of these rights. And since the Second World War, Congress has expanded and strengthened the rights and protections of service members and veterans. These laws are essential protections that guarantee every veteran and active duty service member, including the Reserves and National Guard, the right to be free from discrimination in the workplace on the basis of their military service and the right to their day in court to enforce these protections. But for too long, forced arbitration has eroded these fundamental protections. A coalition of military service organizations representing more than 5.5 million current and former service members notes that countless employers have used forced arbitration clauses in contracts as a barrier to justice by funneling claims relating to wrongful termination and discrimination in the workplace into private, costly arbitration systems set up by the very same employers. For example, Kevin Zoiber, who was with us today, served in the U.S. Navy Reserve since 2008. But in the fall of 2012, he was called into active duty for a deployment to Afghanistan. Kevin notified his employer and conveyed his desire to resume working upon his return. But on the last day of his work before deployment, following his farewell party, he was fired on the basis of serving his country. And when he attempted to hold his employer accountable for violating his rights under USERRA, his company forced his claim into arbitration, citing an arbitration clause in Kevin's employment contract that he was required to sign for employment at the company, waiving his constitutional right to a jury trial. This is outrageous and must be prohibited by law. As a nation devoted to protecting our brave men and women in uniform, we must ensure that their rights to keep their jobs while serving our country, rights that Congress has expressly established, are actually enforceable in court. And the Justice for Service Members Act would do so by ending the use of forced arbitration to erode these important statutory protections for service members, veterans, and their families. I look forward to working with all of my colleagues on both sides of the aisle to fight for the rights of those who have sacrificed so much for our country. Thank you, and thank you, Senator.
Thank you, Dave. And now Congresswoman Sanchez.
Good afternoon. I'm Congresswoman Sanchez, and we are all here today to talk about how forced arbitration really cuts off legal avenues for the average person, oftentimes without them even knowing. I lost my father last year to the cruel disease of Alzheimer's, and I remember the day that we had to move my father into a nursing home. The family obviously was shell-shocked. We were focused on the quality of care and the range of services that the facility could provide him. We weren't thinking about arbitration clauses. And that's the same experience that millions of families across the country who have had to wrestle with the heart-wrenching decision to move a loved one into a nursing home. They're not thinking about the legal ramifications. Fortunately for my father, our family never had to deal with the ramifications of the mandatory arbitration clause. but many families across the country have not been as lucky. We've heard too many nightmare stories about how bad nursing homes have used arbitration clauses to hide their malpractice and deny the families their day in court. To protect those that need the services of a nursing home and their families, I am announcing the introduction of the Fairness in Nursing Home Arbitration Act. This crucial bill will make pre-dispute mandatory arbitration clauses in long-term care contracts unenforceable and restore the full legal rights to seniors and their families. This legislation will not prohibit arbitration, but will simply ensure that nursing home residents aren't barred from exercising their full legal rights. At its most basic level, the Fairness in Nursing Home Arbitration Act is about leveling the playing field for families. We want to protect families and their loved ones who rely on the care of nursing homes, so we must also give them the tools they need to protect their legal rights. I'm proud to join the chairman of the House Judiciary Committee, Jerry Nadler, Representative Johnson, and all of our co-sponsors today as Democrats lead the effort to protect consumer rights. I hope you will join me in supporting these vital pieces of legislation and in protecting our service members, our families, and our workers. Thank you.
Thank you very much, Congresswoman Sanchez. I'm going to now exercise a little bit of presumptuous judgment about the protocol here and introduce Chairman Scott. Congresswoman Bustos, if you don't mind.
I think I will yield to the chair. That's perfectly okay.
I'm in dangerous territory because I'm on the House side and introducing House members. Thank you.
Thank you, Senator, and thank you for your leadership on this and many other issues. I'm pleased to join my colleagues to express our shared commitment to ensuring that American workers have access to the American justice system. This access will be guaranteed with the passage of a series of bills which will prohibit limitation of constitutional right to access to the judicial system. One of the bills, I'll be joining Chairman Nadler and Senator Murray to reintroduce the Restoring Justice for Workers Act, a proposal to end forced arbitration clauses and protect workers' abilities to pursue work-related claims in court. One of the things that the companies are increasingly using are mandatory arbitration agreements which slam shut the courthouse door on their employees, depriving them of their full right to seek recourse for wage theft, discrimination, and other violation of their rights. The Supreme Court's 5-4 decision in the Epic Systems v. Lewis went even further by enabling employers to undermine employees' rights to join in collective or class action suits. The Restoring Justice for Workers Act would reverse the Supreme Court's decision and prohibit employers from mandating forced arbitration clauses as a condition of employment and prohibit employers from requiring employees to waive their right to engage in a joint or collective legal action. I look forward to the day when this legislation will protect workers' fundamental right to have their day in court and join their co-workers to hold companies accountable for unlawful conduct. And I want to thank my colleagues and advocates for continuing to stand up for workers' rights. Thank you.
Thank you very much. I see that my partner, Hank Johnson, has arrived. So again, unless I know that feeling. Thank you, sir. Thank you.
Good afternoon, everyone. I'm honored to be here this morning or this afternoon with Senator Blumenthal and my House colleagues and all of the advocacy groups who are here to support passage of the Forced Arbitration and Justice Repeal Act, also known as the FAIR Act. In her concurring opinion in the 1995 Supreme Court case, Allied Bruce Terminix Companies versus Dobson, Justice Sandra Day O'Connor wrote, over the past decade, the court has abandoned all pretense of ascertaining congressional intent with respect to the Federal Arbitration Act, building instead, case by case, an edifice of its own creation, end quote. Unfortunately, since that time, the Supreme Court of the United States has proceeded with reckless abandon to trash congressional intent as it bends the scales of justice towards business interest with a cascade of rulings imposing forced arbitration against consumers, workers, and victims of civil rights violators. Every forced arbitration case that makes it to the U.S. Supreme Court, the business interests win every time. Forced arbitration forces consumers and workers into a private, for-profit legal system where the deck is stacked against them. Just like big business wins in the Supreme Court, they also win in arbitration proceedings, and workers and consumers lose. The time has come for Congress to level the playing field. Congress must act now to protect consumers, workers, and victims of civil rights violators by passing the Forced Arbitration and Justice Repeal Act, which I introduced today along with about 145 original co-sponsors. The FAIR Act will end the practice of forcing people to give up their right to sue for damages in a court of law. For years, consumers have been forced into unfair, forced arbitration proceedings when they have disputes against businesses and employers. Just by buying a cell phone, signing up for a credit card, or signing an employment agreement, Americans' access to the courts is eliminated. Forced arbitration agreements undermine the indelible constitutional right to a trial by jury of one's peers. It's time to restore the rule of law. The winds of change are at our backs, moving us forward. Last week, Google announced that it is getting rid of forced arbitration clauses in their employment agreements entirely. That's good news, but we need to make sure that more companies are doing just that. We need to fight to defend our constituents' rights and re-empower American consumers and workers. It's time to pass the FAIR Act. Thank you, and I'll yield back to the good senator from the state of Connecticut.
And I'm going to yield to the chairman of the Judiciary Committee, Jerry Nadler.
Well, thank you very much. It is an honor to join with my colleagues today to introduce this important legislation. We have a fundamental principle in this country, and that is that all Americans deserve their day in court. We make a mockery of this principle, however, when we allow individuals to be forced to take their claims to private arbitration, and we deprive them of the protections our judicial system affords. Forced arbitration clauses, usually buried deep in the fine print of contracts that millions of individuals are asked to sign every day, undermine the rule of law in our country. And it's not as if you have a choice. Try when you get a credit card or sign up for a cell phone to cross out the paragraph about individual arbitration. You won't get the credit card, you won't get the cell phone. It is clear that this misleading and unjust practice must end. That is why I am proud to join Congressman Johnson and Senator Blumenthal as an original co-sponsor of the Forced Arbitration and Justice Repeal Act, or the FAIR Act, which would end the use of forced arbitration in consumer, employment, civil rights, and antitrust disputes. I'm also pleased to announce that together with Chairman Scott of the Committee on Education and Labor and Ranking Member Patty Murray of the Senate Committee on Health, Education, Labor, and Pensions, I will soon reintroduce the Restoring Justice for Workers Act. This legislation would end forced arbitration in employment contracts. It would protect workers' rights to pursue work-related claims in court, and it would expressly overrule the Supreme Court's dangerous precedent that dismantled workers' rights to band together to hold unscrupulous employers accountable. Victims of misconduct, whether it be from sexual assault, racial discrimination, employment violations, or corporate abuse, deserve their day in court. They deserve the full protection of their rights under federal law. As chairman of the Judiciary Committee, I am committed to advancing legislation to restoring these rights and to end forced arbitration, and certainly these two bills. Committed to passing these two bills, not to ending them. I look forward to working with all of my colleagues here today to reach that goal. Thank you.
We have been going in reverse order of importance. I went first, and I'm now very, very pleased and honored to call on a real champion for consumer, employment, antitrust, and civil rights, Congresswoman Bustos. Thank you.
Thank you, Senator. Appreciate it. And I don't know if I agree with you about the reverse order, but thanks very much. You know, those of us here in the front row, the members of the Senate and the Congress, the House, we're just a conduit to help the people right behind us who deserve to have senators and House members fight for them. And the message that I'd like to deliver loudly and clearly to every CEO in this country, to every business leader, is to end forced arbitration now. We have 60 million Americans that are working under these clauses in their contract agreements that they don't even know what they say. I mean, think about that on day one when you go into the workplace and you're signing off on, you know, that your insurance and your where you're going to park your car and all of that. In there is this forced arbitration clause, and that takes away the rights of 60 million Americans. And so that is why those of us, the members of Congress, of the House, of the Senate, are standing here to help the folks behind us. I want to call to your attention to your right, Gretchen Carlson. She is a fighter. She's an advocate. She was a national television anchor, and she and I have worked hand in glove to introduce a piece of legislation that we are reintroducing this Congress called the Ending Forced Arbitration of Sexual Harassment Act. And we are reintroducing that today because of what Gretchen has had to endure and what I learned through the good journalism at the Washington Post. I'm a former reporter myself, and I woke up to read this article in the Washington Post that detailed in a graphic way what women who worked for Kay Jewelers and Jared Jewelers had to go through. They would go to these conferences where, by the way, spouses were not allowed, and attendance was mandatory, where they would be groped. And there was the leader of the company who, if a woman wanted to be promoted within that company, had to have sex with this leader within the company. So why do we need this to end forced arbitration in sexual harassment? Because of cases like that. Because of what Gretchen Carlson had to endure. Because what these women had to endure at Kay Jewelers and Jared Jewelers. And there are many other examples in companies all over this country. So if it's not now, then when? There's not one person who's standing behind us who should have to endure this for one day more. So again, to the message that we would like to deliver, end forced arbitration now. It can't happen soon enough. I call on my colleagues in the House, my senators, on the Senate side, Democrats and Republicans, to work together to pass this legislation. Thank you very much.
I really want to thank all of my House colleagues, and I know you have votes and committee hearings and so forth. We're going to continue now with the advocates who are really the voices and faces of all of the victims who have suffered from these practices. Tori, if you would go ahead.
Thank you, Senator. It's my pleasure to introduce Levi Bartos from Ohio.
Thank you. I'm Levi from Ohio. I also used to work for Chipotle and was forced to work off clock without pay. Chipotle has forced me and thousands of others like me into arbitration. I wanted to work for Chipotle because, as a customer, the employees always were friendly and talked to me like I was a human. But it turns out, as you are a worker, you are treated like a robot, auto clock out by midnight, and a computer, and forced to keep working without pay. Forced arbitration took my rights away, and that's why I'm asking the Congress to end forced arbitration and to restore justice for me and all Americans. Thank you.
I'd like to introduce Lily Silbert from California.
Hi, I'm Lily from California. I was sexually assaulted by my massage therapist during a massage at Massage Envy, and it was terrifying, and I'm not alone. I brought a lawsuit against Massage Envy like hundreds of other women who were also assaulted. After my assault, I tried for a year and a half to cancel my monthly membership. Out of frustration, I downloaded the Massage Envy app on my iPhone to cancel my membership, but hidden in the fine print of the app was an arbitration clause. Now the company is trying to force my case into arbitration, even though I tried to cancel my membership through the app after I reported that I was sexually assaulted. Massage Envy wants my case and others like me to be forced into arbitration, to keep it secret, and to deny me my constitutional right to a day in court. I didn't want to be a victim. Forced arbitration is trying to take away my rights. That's why I'm asking Congress to end forced arbitration and to restore justice for me and all Americans.
Thank you. It's my pleasure to introduce Kathy Greiner from California.
Hi, I'm Kathy. I'm from California. I was a DirecTV customer for over 5 years when my equipment stopped working. Because of their poor service, I canceled DirecTV. They immediately withdrew an early termination fee of over $200 from my bank account without my permission. When I called my bank to reverse the charges, DirecTV tried to ruin my credit. We had no signed agreement, but DirecTV claims they didn't need one and that they could change the terms of service at any time, including adding a forced arbitration clause. I am part of a lawsuit with over 700,000 DirecTV customers who were unlawfully charged fees. After 10 years of trying to get our money back, DirecTV continues to block this lawsuit and is attempting to force me and all other California customers into arbitration. Forced arbitration took away my rights. That's why I'm asking Congress to end forced arbitration and restore justice for me and all Americans.
Thank you. My pleasure to introduce Akela Edwards from Arizona.
Hello. I'm Akela from Arizona. Took out payday loans when I was in college supporting my family, struggling to make ends meet and living paycheck to paycheck. The lenders charge illegal interest rates, some rates as high as 1,000%. One loan was even automatically renewed, which is also illegal. Forced arbitration means I cannot hold those lenders accountable. Forced arbitration took away my rights. That's why I'm asking Congress to end forced arbitration and restore justice for me and for all Americans.
Great. Thank you.
I'd like to introduce Tia Holloman from Maryland.
Good afternoon. I'm Tia from Maryland. I was training to be a manager at my job when I endured 2 months of sexual harassment by my boss. I reported this sexual harassment to another manager who did nothing. There is a video of the time that he grabbed my hand and twisted my arm so badly that I had to go to the hospital. When I tried to hold the company accountable, I was forced into arbitration. Forced arbitration took away my rights, and that's why I'm asking Congress to enforce arbitration and restore justice for me as well as all Americans. Thank you.
It's my pleasure to introduce Glenda and Peter Perez from Florida.
Good afternoon. I'm Glenda, and this is my husband, Peter. We're from Florida. We used to work for the same company. 2 years ago, our employer fired me after I reported racial discrimination and then forced me into arbitration. The arbitrator sided with my employer, and I lost. Afterwards, my husband saw a photo of the arbitrator cozied up with the attorney for our employer while at a party, and when he complained, he was fired. Our story could easily be yours, but you would never know because forced arbitration requires silence and favors corporations. So I am proud to stand here thinking of my 3 kids and their future career in order to share my family story, showing why forced arbitration must end. That's why I'm asking Congress to end forced arbitration and restore justice for myself and for all Americans. We are counting on you.
Thank you.
Thank you so much. I'd like to introduce Kevin Zoiber from California.
Thank you. Good afternoon. I'm Kevin Zoiber, a Navy reservist from California. In 2012, I was called upon to deploy to Afghanistan. On my last day of work before deployment, my employer, BLB Resources, a federal contractor, hosted an office party that included decorations, cards, gifts, and even a cake that said best wishes with an American flag. Later that same afternoon, BLB told me I was being fired, and that my position would not be available when I returned home from military duty. When my deployment ended, I tried to enforce my right to return to my job under a federal law called the Uniformed Services Employment and Reemployment Rights Act, better known as USERRA. USERRA bars employers from firing workers when they take time away from their civilian jobs to serve their country in the armed forces, and gives them the right to return to their civilian jobs after serving. However, I was denied the ability to enforce my USERRA rights in court because BLB had required all its employees to sign an arbitration agreement as a condition of employment. This mandatory arbitration agreement stripped away my constitutional and federal rights to seek justice in a court of law. Forced arbitration eviscerates the special rights Congress has bestowed on service members since the 1950s. That's why I'm asking Congress to end the practice of forced arbitration, not only to restore justice for those who serve our country, but for all Americans. Thank you. Thank you, Senator. Thank you.
It's my privilege to introduce Gretchen Carlson from Connecticut.
Good afternoon, everyone. On July 6, 2016, my story about sexual harassment and my case against the former chairman and CEO of Fox, Roger Ailes, became public. It ran like wildfire across Twitter, the breaking news alerts all around the world. Back then, I could have never known that I would become one of the prominent faces of not only harassment in the workplace, but fighting against forced arbitration. But over the last 2.5 years, we've experienced a tidal wave of women who have joined me in this fight, courageously speaking out. And here's what I found out. Courage is contagious, and the cultural revolution that we are now experiencing is long overdue. The first step was for me to tell the truth. The next part of my mission was to change the system. So I spent much of 2017 and 2018 walking the halls of Congress, reaching out to members of both parties. And in December 2017, I was proud to be a part of introducing the Ending Arbitration Act of Sexual Harassment, a bipartisan bill in the House and the Senate. Today, we are reintroducing that bill in the House in bipartisan fashion. Representative Stefanik on the Republican side, Representative Bustos, who you just heard from, on the Democratic side. And this bill will also be reintroduced in the Senate. That is forthcoming. So why is this bill so important to me? Because unfortunately, almost every woman in our country has a story of sexual harassment. And I've talked to thousands of those women over the last 2 years. They've shared their emotional stories of pain with me and shame. But what they've really shared with me is how they were silenced. You see, arbitration is the harasser's best friend because it silences all of the victims. This is how it hypothetically works. A woman's being sexually harassed on the job. She goes to HR to complain. They immediately throw her into arbitration because she probably has one of those clauses. No one will ever know about her story. More than likely, she'll be blacklisted, demoted, and then fired. She may get a paltry settlement in arbitration, but then she'll find out she has no appeals. She can't bring the same kind of evidence to arbitration. And hypothetically, this woman will probably never work in her chosen profession ever again, and that is outrageous. No one else at her place of employment will know what happened to her. And here's the worst part. Her perpetrator will get to stay on the job because it's secret. The bottom line is none of us up before you today ever expected to get into a dispute at work. I know I sure didn't. But to be silenced after simply having the guts to come forward, that is unjust. And that is un-American. And now we're seeing the effects of people speaking up and seeing that their voice does matter, and they're actually being heard. So after we introduced the bill in late 2017, Microsoft stood up and stepped up to the plate and said, we're taking arbitration clauses out of our employment contracts. Then Uber and Lyft. Then after the Google walkout, Google eBay, Airbnb, Facebook, and just 2 days ago, Vox Media. Turns out, it's not just courage that's contagious. Action is also contagious, and those voices matter, and they're being heard. So now it's time for Congress to show that they're going to take action in a bipartisan way, because the biggest lesson that I've learned in this process is that sexual harassment is apolitical, and that's why we should all care to come together to fix this. In this cultural revolution, it's time to get by something and behind something that will really make a difference for women in our country. And it's my great hope that we will get it done in that bipartisan way for women, for men, for my children, and for yours, and for our country. Thank you. And now I'd like to introduce Jeff Gavin, President of Heart Research.
Thank you very much. We conducted a poll about forced arbitration with a representative cross-section of 1,200 Americans who are registered to vote. The interviews were conducted in the second half of January. The sample, just so you know, is about 5 points Democratic. But as you'll hear, the partisanship of the sample is not particularly important because the support for ending forced arbitration crosses party lines and is broadly shared across the public. Let me just make a few of the key points about what we learned from the survey. The first point is that Americans who would find themselves in a similar situation don't want to be forced into arbitration. We asked people if they believe they had been harmed by a company's negligence, either physically or financially, would they prefer to have their claims decided by a judge and jury or through arbitration? And by 2 to 1, Americans say, in those circumstances, I want to have the right to have my claims heard by a judge and jury. Underlying that is an understanding or recognition that many Americans have that the system of forced compulsory arbitration is a rigged system. They recognize that it does not exist for the benefit of consumers or employees, but for the benefit of corporations. In fact, when we ask people who mainly benefits from this system of arbitration rather than allowing people to take their claims to court, by a margin of close to 9 to 1, people say this is a system that benefits, mainly benefits corporations as opposed to mainly benefiting consumers and employees. You can see in the chart behind me, maybe you can see, that we asked voters about 2 different circumstances what they think ought to happen or what's the better way to deal with claims by consumers. First, when there are claims by consumers against companies, is it better to require the use of arbitration for all claims, as many companies do, or better to give consumers a choice of using arbitration or the courts for each claim? And you can, for those consumer claims, by a margin of 84 to 16, Americans say it is better to give the choice to the consumer and not to allow corporations to mandate arbitration. In terms of employment claims, when people are asked about the better way to deal with claims by employees against employers, by 81 to 19, they say it is better to give employees the choice of using arbitration or the courts for their claims rather than allowing companies to require and mandate compulsory arbitration. When we ask about this principle in terms of legislation, on the next chart, you can see that there is overwhelming support for the legislation that would accomplish what the FAIR Act would do. When we talk about a bill that says companies cannot require the use of arbitration when a consumer or employee has a dispute or a claim, and that under this legislation, consumers and employees would have the choice of taking their claim to court or submitting it to arbitration. 84% of Americans, registered voters, say that they would support this legislation, and only 11% say they would oppose it. I mentioned the strong bipartisan nature of the response here, and you can see this on the chart. Among Democratic voters, by 83 to 12, they favor the FAIR Act. Among independent voters, by 80 to 11, they favor the FAIR Act. And among Republican voters, by 87 to 9, an even greater margin than among Democrats, they favor the FAIR Act. Among Americans who told us they voted for President Trump in the 2016 election, by 86 to 9, they favor this legislation. And even if you look at the most conservative Republican voters, by 89 to 7, they support the legislation. So the short answer is the American people are with you. In fact, as part of this, our research, we were able to tell our respondents stories very much like yours. And it's not their hearts are with you and their votes are with you when they think that what the kinds of treatment that each of you suffered and that others like you did is unfair and unjust, and they want Congress to remedy it. Let me just close by talking about three things in particular that Americans overwhelmingly find egregiously wrong with the forced arbitration system. The first is that arbitration procedures keep corporations' negligence and bad behavior secret. And for example, employees will not learn that a supervisor had sexually harassed female employees. 73% say that that's a very serious concern about the arbitration system. Related to the secrecy of the system, forced arbitration puts public health and safety at risk. If corporations know they can't be held accountable in court, the cars we drive, the medicines we take, and the foods we eat will be less safe. 73% find that to be a very serious concern about mandatory arbitration. And then finally, that forced arbitration prohibits consumers' employees from suing a company even in the case where a company broke a federal or state law against discrimination based on gender, race, age, or disability. Again, 73% of Americans say that that is a very serious problem with forced arbitration. So the bottom line is Americans get it. They get that this is a system that is rigged, that is not fair to the average worker and the average consumer, and they stand behind the effort you heard about today for Congress to take action to remedy this and end forced arbitration in our country. Thank you.
Thank you, Jeff. Let me just close the program. We may have some time for questions by saying Americans want this kind of change. They know this system is secret, it's rigged, it's unfair, it's un-American. Americans want it to end by overwhelming majorities, whether they're Republican or Democrat, no matter where they live. And if they have any doubt about these numbers, they have only to talk to people in their own communities whose stories parallel the ones you've just heard. I want to thank the Association, American Association for Justice, for the polling that you did, Jeff. I want to thank all of the advocates who are here today. We do hope that courage is contagious, that action will follow it, that other companies will follow the leadership by example from the ones who have already committed to end it, but we're not willing to wait for voluntary action. We are not willing to wait for corporate America to do the right thing. This kind of injustice has to end for the sake of everybody in the workplace, men and women, for the sake of all consumers who buy American products, for the sake of everybody who endures civil rights injustices, for the sake of everybody who wants to bring antitrust challenges. The FAIR Act is a measure whose time has come, and we are looking truly for bipartisan support. So I want to thank all of you who have come from all over the country. My constituent, Gretchen Carlson, of Connecticut, and I particularly want to single out Kevin Ziober. Thank you for your service, Kevin. Thank you for your service to our nation. And your story, I think, is just such a powerful, heartbreaking example of un-Americanism in the workplace that results from this kind of practice. I'm presuming everybody is either exhausted or all of your questions have been answered. I have to go to a vote myself, so if you would excuse me, I'm going to take off, but thank you all for joining us.